Right now, we have our SEC Best Practices panel. They are going to focus on best practices in testimony, the Wells process, settlements, and APs. Lara Mehraban will be our moderator for this panel. She is a partner at Sidley here in New York. Before joining Sidley, she served for 15 years at the SEC, where she held various positions, most recently acting as the director of the New York Regional Office. Prior to that appointment, she supervised the New York office's enforcement division as an associate regional director. We also have Sheldon Pollock. Sheldon is an associate director for the Division of Enforcement in the SEC's New York Regional Office in that role. Sheldon oversees the SEC's enforcement program in New York. Prior to becoming an associate director in 2022, Sheldon served for over 6 years as an assistant director in the enforcement division. I realize I'm going out of order here. That's my mistake. Between the two folks.
Only our mother can tell us apart.
Here we go. So Zach Brez is based here in New York, where he is a partner in Kirkland and Ellis's Government Regulatory and Internal Investigations Group. Prior to joining Kirkland, Zach was a staff attorney in the Division of Enforcement at the SEC. Moving on down the line, we have Lorin Reisner, who is a partner at Weiss in New York. He is co-chair of the White Collar and Regulatory Defense Practice and a member of the firm's management committee. Lorin previously served as chief of the criminal division of the U.S. Attorney's Office for the Southern District of New York. He also served as deputy director of the enforcement division at the SEC. And last but not least is Junaid Zubairi. Junaid is a partner at Vedder Price in Chicago, and at Vedder Price, he is chair of the firm's government investigations and white-collar defense practice and a member of the firm's board of directors. Prior to joining Vedder Price, he was a senior attorney in the SEC's Division of Enforcement. Thank you all for being here, and please take it away.
Great, thank you very much. I'm excited to talk through the issues of best practices in testimony, Wells process, settlement, and APs with this distinguished panel. I'm not sure why it's best practices and not a master class, but we can ask Bruce about that later. But really, by the time you get to testimony and SEC testimony, you really have your strategy baked in. And so I think we should take a step back, go well before testimony, the first time you're getting a reach out from the commission. What kinds of strategic decisions are you thinking about when your client gets that reach out? What are you talking to your clients about? How are you thinking about whether to take a proactive or a reactive approach? And so why don't you talk us through, Zach, some of those early conversations with your client and with the staff? What kinds of things are you thinking through just at that very early stage?
Yeah, sure. I think it's a great point. I think you've got to start thinking about strategy before your first conversation with the staff. I mean, frankly, you're probably thinking about it at your first call with your client. I think the days of our clients saying, hey, I got the subpoena from the SEC, can you handle it and tell me how it goes, are long gone, right? They are much better purchasers of legal talent. And so I think they want to be involved in the strategic decisions before your first call with the staff to say, I've got your subpoena, right? And so I think there's a couple of buckets, right? One certainly is going to be like, what does your client know about this matter, right? Have they looked into it already? Have you done an investigation on it? Are they bringing up a new issue? Was there just an article in the paper? All those things are going to impact how you handle it. I think a second is going to be relative for them timing. 7 times out of 10, clients say, I want this done as soon as possible. And 3 times out of 10, clients say, like, if you can punt this to 5 years from now, that'll be too soon. But I think you need to have that feel from them about urgency. Typically, particularly for public companies, the sooner the better this is finished. But even in the asset management space, in the private space, the sooner the better, right? And so I think you want to think about, okay, how am I going to accelerate this, get the staff what they want, speed things up, make this easier for them, and get to the finish line as fast as I can. I think those are 2 of the things you want to think about. I think the third thing you got to think about too is, like, am I only going to be talking to the staff here? Or is this a criminal issue? Is this a state issue? I recently had a first meeting with the government, and 31 attorneys showed up from like 9 different agencies. So I think you have to be prepared to start thinking about how you're going to strategically handle all versions of that. But all of that, I think, has to happen before your very first call with the staff to say, hey, I got your subpoena. I don't know anything yet, but some version of that.
Great. And Lorin, what about you? What are some effective strategies for those early interactions with the staff?
Yeah, well, Zach makes a very good point. A lot of that is going to depend on what your client's objectives are, what your client's instructions are, what your ultimate strategy is. But I think there are at least three principles that probably cut across any strategy when first interacting with the staff. The first is credibility. You want to make sure the staff knows they can rely on you and you establish credibility with the staff. You want to tell them that you're committed to respond to their requests promptly and thoroughly, and you want to demonstrate that early on, that you are responding to their requests promptly and thoroughly. Look, a lot of us know going in, we're going to ask for narrowing of requests. My experience is that's a bad topic on the first call with the staff. You'll get there, but establish your credibility before you begin to ask for compromises. The second is information gathering. Get as much information from the staff as you can in your early conversations with them. In general, you don't get much when you say, what can you tell me this investigation is about? Or what can you tell me about the investigation? A smarter approach is to look at some of their requests, raise the request with them, say, I see you requested this. Can you tell me a little bit more about your concerns along, in that area or in that, about those documents or with respect to that topic? You may still get a goose egg, sometimes you just do, but I think you're more likely to get something useful when you ask the question in that way. The third is be ready to present your affirmative position as early as possible, if you can, in the first call, gently, with the staff. Now, sometimes you don't know what your affirmative position is at the outset, and you have to do more fact development and legal analysis before knowing precisely what your overall strategy and your legal and fact position is going to be. But as early as possible, begin to plant those seeds, even if it is with some caveats. We're still doing our fact investigation. We have more work to do. However, I think what we're seeing is fill in the blank, begin to plant the seed of what your advocacy might be later on. So those are the things that I think about in my initial interactions with the staff.
Yeah. Also, of course, like depending on the type of subpoena you're getting, looking at the name of the formal order and seeing like, is my client the subject of the formal order or subject of the investigation, or is there some room for play here? Like what kinds of questions am I going to need to be asking? Junaid, what are the circumstances in which you might want to seek to do like an early white paper or an early attorney proffer?
Yeah, I think Lorin built a great foundation for this, which is really it's about cooperation, whether if you're going to go down the road of cooperation and you want to maximize credibility, you want to demonstrate by doing and not saying. An attorney proffer, PowerPoint presentation, early meetings where you've conducted a thorough look into the facts, an internal investigation, and you want to go in and demonstrate cooperation. I find those to be very effective for a whole host of reasons, to really do and show cooperation, and also it really structures the investigation. You kind of create a roadmap for how the facts are going to be viewed. You create some efficiencies by identifying the critical people that have information. So the staff is really focused on if they're going to take testimony, seek documents. It really helps facilitate an efficient way of conducting an investigation. And for selfish purposes, it really helps them not meandering and going into areas where you just don't necessarily want them to go or they may not be focused on. As far as white papers go, I think those are certainly effective, but probably a little bit later down the road when the issues are more ripe. If it's a really critical accounting issue or some complex area of the 40 Act, for example, and you need somebody to come in and really provide an expert lens and really dig into it. I find those to be more effective, a little bit down the road when the facts and the legal issues are more clear.
Yeah, that makes sense. Lorin, I'm going to toss this out to you, but feel free to not answer. Are you going to change any of your early interactions with the staff, now that the administration has changed?
Probably not. I mean, certainly none of the three principles I just outlined. At the margin, there may be some different strategic approaches. Look, the Holy Grail, although, it's really not possible and, 9 out of 10 or maybe 98 out of 100 matters, is to persuade the staff early on that they shouldn't go forward with the investigation, that they should issue a termination notice sooner rather than later, or immediately. I think there may be opportunities to argue, for example, that the concept being promoted by the staff in an investigation, as much as you can see in an initial request for information or a subpoena, is a type of regulation by enforcement, where there are no clear rules and enforcement is being used to establish some regulatory aspiration or policy. I think everybody, conventional wisdom, and I think it's right, is that this new commission will be hostile to so-called regulation by enforcement. And if you have an opportunity to persuade the staff that this is a matter that truly falls into that category, you may have some traction in making that argument. Another area where I think at the margin there may be changes in practice is during the last 4 years, very often when you identified comparables or precedent to the staff, once in a while you heard back, well, those comparables don't apply anymore. Those precedents don't apply anymore. That's some. I think that the incoming commission will be more respectful of precedent in comparables, particularly when it comes to corporate penalties, in a way that the prior commission was not. And related on corporate penalties, I think that there will be opportunities to argue no actual harm to investors and no actual benefit, no financial benefit to the corporation, in order to have potentially constructive conversations around appropriate corporate penalties.
Yeah, probably a later in the investigation argument, but good to be thinking about those things from the get-go. Sheldon, let me turn it to you. Can you talk a little bit about strategies that you have seen from counsel early on in investigations that have been effective, or vice versa, things that you've seen people do that have not been effective?
Sure. Just as to give you all the disclaimer that I'm sure you've heard 900 times today, my comments today are provided in my official capacity as an associate director of the Division of Enforcement here in New York, but do not necessarily reflect the views of the commission, the commissioners, and members of the staff. So on this point, I think my first point to the audience would be that I don't like to give advice to the defense bar. Everyone on the panel and many in this room have served on the staff, and everybody has their own unique styles, and something may be effective for Lorin, might not be effective for Lara, and vice versa. And so there's no one-size-fits-all approach. A couple observations, though. Steve Pekin mentioned this in a speech back in 2018, that open, effective, and productive dialogue between the government and defense counsel is crucial for both sides in handling a complex securities matter. And I think that's kind of how I think about these kinds of issues. Many of the issues we deal with on the staff are just really complex. And for us, productive communication with defense counsel can give us a better understanding of complicated financial products, insight into businesses and business processes that we may not be familiar with. And so early communication allows us to very much focus an investigation on the key issues so everyone stays efficient. I think where there can be some friction between the staff and defense counsel, and look, everybody should be zealous advocates, and nothing I say here today should dissuade anyone from acting in that way. But one of the biggest challenges is making sure we have all the operative facts before us on the table by the time we're talking resolution or getting to a Wells meeting or when I'm conducting an evidence review with the team. It's very challenging for us to progress an investigation if our staff are surprised with new facts after a testimony has happened, at the beginning of the Wells discussion, during settlement talks, particularly if defense counsel takes the position that those facts are central to a case. And I'm not talking here about the occasional inadvertent production or inadvertent failure to produce a document. What I'm focusing is on the sort of unexplained issues that may delay productions, and I think that's where it sort of undermines our process and erodes the trust that Lorin was talking about. And so resolving that friction to the extent it exists involves good communication with the staff, committing to a production timeline for documents and things like that, helping us identify documents that folks believe are important to their case. Or if there's a document that's challenging for the client, not surprising us late in the game with that, and sort of having a colored explanation where we weren't able to investigate it. So I think that's what I would sort of say to that.
Good advice. So we've covered now sort of the early stages of an investigation. Let's talk a little bit about best practices in testimony. There are a lot of strategy decisions to think about when you get to the testimony phase. Before we even get to testimony itself, there's strategy considerations in what format the testimony or an interview should take. Should there be an attorney proffer? Zach, why don't you talk through some of the things you're thinking about when figuring out how to best get the evidence to the staff?
Sure. I think some of it depends on the nature of the case, right? If you are, going to your point about the title of the case, of the investigation, if you are a victim or a third party here, but there's some hair that could come out of the like, or you have particularly skittish witnesses who are likely to be poorly received by the staff when they act skittishly. I think it's important to try and push for, at least initially, interviews. I think there are going to be certain cases, obviously, where it's going to be on the record. It's not worth having that debate. But there are some where, in fact, I think both sides can benefit from certain interviews being interviews and not on the record, particularly where there's a witness who is going to be a terrible on-the-record witness because they're going to be scared of their own shadow, no matter how much prep you work on them with. And so for them, I think you will come across as a more credible outside counsel, more credible respondent for the staff if you can get your witness to feel comfortable discussing the issue with them. And so while sometimes staff says for one reason or another, we're doing this on the record, I've had a lot of success in instances where it is follows up out of it. We say, let's do this as an interview. In other instances, it's going to be a full day, and so you should ignore that piece and march forward with the prep of your witness and get them ready for that moment.
Yeah. Junaid, what do you do if you're unsure whether there's a parallel criminal proceeding?
Yeah, I think you really have to focus on the facts and look at, are we dealing with something that's super technical and highly unlikely that it's going to result in a criminal investigation, or are you dealing with something that's pretty obvious and everything in between, the forging of the documents to the technical case? There's probably a lot of gray area in between. And you really have to sort of see how your client fits into that mix and make a determination as to which route you're going to go. You go into early testimony, you're locked in, you've got to deal with that. And under those circumstances, if there's a substantial risk, I certainly would be pushing for early meetings, attorney proffers, or trying to do some kind of a proffer where you're not on the record through testimony. And depending on the relationship with the staff attorney and kind of the tone and tenure of the investigation, you could ask. All right? The staff attorney is never going to come out and say, yes, there is a criminal investigation. But I've had circumstances where the conduct could clearly be viewed through a criminal lens. As an example, in a exam, an employee forged documents and submitted them to the exam staff. We conduct an internal investigation, learn of that, do a self-report. Very sympathetic employee, right? And did it not from any pressure, but just bad judgment. And had a very candid conversation with the SEC staff. And look, we've got concerns, right? I mean, is this going to go next door or is this going to stay here? And had a very candid conversation in which, without any assurances, the staff said, look, we're not interested in making this any bigger than we need to. So if you have that relationship and you could sort of leverage that, that will give you some benefit of just frankly asking.
Yeah, it comes down to communication and credibility again, so we'll keep circling those two, I think, themes. So Lorin, preparing clients for testimony is probably one of the most important things that outside counsel does. What are some best practices or tips you have for preparing your clients to go in under oath? And what are some pitfalls also?
Yeah. So, look, I think, not to overdo this, but getting the witness comfortable with the documents that they're likely to see is probably the most important thing that you can do with a witness in advance of testimony. The greatest compliment that my colleagues and I are paid after testimony by a witness is a witness who says, boy, I looked at every document that I was shown in advance of my testimony, and there's maybe we didn't anticipate every question, but we anticipated all the topics that were covered during testimony. So I know it's not that sexy or exciting, but being familiar with the documents and making sure that your witness is familiar and comfortable and has thought through the key documents in advance of testimony is critical. SEC testimony is different than a deposition. You hear lawyers conflate the two sometimes, but there is a difference. The key differences are evasiveness is never going to work for a witness who's testifying in an SEC proceeding. Nothing good is ever going to come out of that. Where I'm told by my colleagues who do more civil litigation than I do that there is a certain amount of evasiveness that takes place in civil depositions that really has no place and is not going to score you any points or get you any advantages in SEC testimony. Similarly, sparring with the questioner, that's like it's never a good approach for a witness in SEC testimony. Again, I hear that in civil litigation, there's a certain amount of sparring that may take place between witnesses and lawyers doing questioning. But advising your client, counseling your client, regardless of what happens on the other side of the table, no matter how difficult the question is, no matter how ridiculous you think the line is, don't spar, don't fight, just answer the question truthfully and to the best of your ability. That's going to score you more points than any other approach.
Just on that piece, I'm curious, Lorin, Junaid, your views on this. Whenever you're prepping a witness who's the controller for the Eastern Widget Division, there's going to be a lot of show them the documents, get them comfortable, let them know what's going on. I think the hardest one, and one that candidly I struggle with sometimes, is the master of the universe witness who has achieved their level of success because they didn't listen to their idiot lawyers. They've achieved their success because they were born right and nothing has gone wrong. 15 years ago, I had a witness like this in Philly, took him in for testimony. Midway through testimony, he turned to the staff attorney and said, listen, my lawyer told me not to discuss this with you, but I think, and there was like, oh, fuck, it didn't go well. I got charged. It was not great, but I think that's the one I struggle with the most is prepping the witness to not think that they're going to come in and I don't know if it's charm or win over the staff somehow, or they're going to just, if the staff only would listen to them for 8 hours, things would go great. So I'd love any tips you guys have, because I'll take them and I'll use them myself. I find that the toughest witness to prep.
100%. And look, the most important advice and the toughest thing for witnesses in that position, we call it, CEO disease or CEO-itis. The toughest response for them to give is, I don't know, or I don't recall. And it turns out that I don't know and I don't recall are going to be truthful answers by senior leaders of organizations in some circumstances. Zach, I have no magic formula other than just to impress that upon them. And I do have some war stories that are similar. I have one war story that's similar to your war story and it's on the record. I have the transcript where I have a client who did almost exactly the same thing and started an answer with, my lawyer told me not to do this, or my lawyer told me not to volunteer information when I'm not sure of the answer, but here you go, here's my speculation. And there are some people that no matter what you do, there's nothing you can do, but most of the time, the vast majority of the time. And some of this goes back to sort of credibility and trust with the client or the witness, developing credibility and trust with the witness so that they take to heart the advice that you're giving them, combined with maybe a war story or two where it was a disaster, is the best approach to getting the senior leaders to answer, I don't know, or I don't recall, where that's the truthful answer.
And also a lot of practice, putting them through, like, I'm going to play the SEC attorney and I'm going to question you. And it's not just you, have like other people do that as well. I'll have each of the associates
let them hate somebody else.
Right,
yeah.
Try everyone and get them to that position where they're uncomfortable with you. And then say, see how this can go.
Yes, yeah. Bring in somebody else that can hate them, have that person drag them over the coals.
Yeah. So Sheldon, I know it's probably pretty rare for you to attend testimony. Are there any circumstances where you do attend testimony? And if you're not attending testimony, how are you getting up to speed on the facts of the cases?
Sure. I mean, one of the best parts about joining the SEC is you get to run your cases, and everybody who's alumni here in the room that's one of the attractive things. And that responsibility includes taking testimony. And so generally in the room, it's the staff's manager, the assistant director, and maybe the trial counsel, depending if we think the case may be heading toward litigation. And so that's the general practice, so it's pretty rare, you're right, for me to attend testimony. We're hearing about it from the staff either through the quarterly meetings, so every quarter we sit down with the assistant directors, we go through the dockets, and we're kind of hearing, and how did it go, what happened this quarter, or if it's the very crucial witness in a kind of a case that you're aware of, we are asking, how did the testimony go? And sometimes people come into our office and they'll be like, oh, we had Lorin's client in, and guess what they just told us? They committed security, something like that. So it just really, that's sort of how we're hearing it. We love these witnesses, by the way.
So do you have any advice for counsel who are bringing witnesses in for testimony?
I mean, again, on the condition, I don't love to give advice to seasoned defense lawyers. I think it's important to maintain trust between the staff and I think that would be it. Credibility and trust is really, really key. And I think the panelists here sort of explain that. So.
Yeah. All right, so let's move a little bit further along in the timeline of the investigation to sort of the Wells process, settlement discussions. Sheldon, on the commission side, you're at the end of evidence gathering. Sometimes the staff decides to do a reverse proffer. What circumstances do you think about when determining when to do a reverse proffer, and what does the staff want to accomplish with that?
Sure, yeah, and first of all, just to set the table, what is a reverse proffer? A reverse proffer is a meeting, it's generally toward the end of a case, between the staff and the defense counsel, and sometimes their client, sometimes the client come, where rather than being in listening mode, where we often are at a Wells meeting or Wells presentation, we, the staff, share our key findings, the proposed charges, and our hope for a proposed resolution. And the goal from our perspective is to hopefully shorten settlement discussions by convincing the other side that we're prepared and determined to move forward with a litigated case in short order, that we have strong proof, and that as a result of the presentation, hopefully we can achieve sort of a workable resolution. Now, for our staff, preparing an effective reverse proffer takes a lot of effort, a lot of work, especially in the more complex investigations. And so we don't do them in all cases. We're not going to do one if there's an undercover criminal investigation, if the key evidence is really known to both sides and we don't think a presentation is going to be effective in sort of moving the needle, or if we're convinced for other reasons that there's really no chance of settlement before we file charges. So they're not for all cases, but that's sort of what is a reverse proffer and sort of when we use it, why do we do it? For us, it's helpful because the work that our teams need to do to gather our best evidence and theories often overlap substantially with the things we would do for an evidence review. So the work product of putting that together is really important, and it forces us to consider how to best affirmatively present our case to an outside party. And that process can clarify our thinking, I think, in a way that a Wells meeting or a Wells process or even the action memo process wouldn't do. And so that may include adding charges, dropping charges as we're kind of discussing it. And if it's done well, as I mentioned, it can sort of short circuit the time towards settlement and make the end result more efficient.
Can I make one observation on
Sure.
the reverse proffers, which can be terrifically useful because you hear directly from the staff their view of the evidence, their theory of the case, their charging thoughts. But be careful what you ask for when before asking for one of these reverse proffers, because I think what can happen is when the staff goes through the exercise of putting together a reverse proffer, it's a big investment of resources by the staff, and the staff can, God bless them, get locked into positions as a result of that investment of resources and fall more deeply in love with their case before you have a chance to maybe address issues on a seriatim basis. So reverse proffers can be very advantageous from a defense perspective, but I generally try to engage the staff on both fact issues and sort of core issues along the way before waiting for a reverse proffer. Again, sometimes the staff isn't willing to be engaged in those discussions, but more often than not, they'll have that conversation with you.
Yeah. Junaid, what kinds of things are you thinking about when you're making your decision whether or not to make a well submission?
I think before you get to the wells, you have a lot of times you've got pre-wells meetings, you've had white papers that have been submitted, you've done presentations. So I'm really looking at it from the standpoint of, okay, where are we at? I mean, are we going to have an issue that we're just not going to see eye to eye, whether it's legal or factual, and is litigation almost inevitable? And if that's the case, then you really have to think twice about whether or not you want to put pen to paper, submit something in writing, and then ultimately, live with whatever you wrote. So the wells process, historically, I was just prepping for this earlier, and somebody distracted me and they sent me a text. Being from Chicago, I got a note saying, "Can you believe it's been 50 years since the Bears drafted Walter Payton?" I'm like, wow, that's a long time ago. So I went back, and of course, what anyone else in this room would do, saw how old and when the Wells Committee was convened, and it was more than 50 years ago. So there was a lot of thought that went into what the Wells process was meant to be and how that process sort of played out over years. Over the last, I'd say, 10, 15 years, it's been a disappearing process. And you're not seeing access to the evidence that you would typically. And if you have access to information and you're going in and you're able to cite to transcripts, look at all the documents that were produced, and can really submit a fulsome response, I think that's really beneficial to having early settlement discussions possibly, or convincing the staff that they might not have it right, or the staff convincing you that, hey, we got the better argument here. And I think that part is lacking, and hopefully we see more of that.
Interesting. So let's say you've submitted a well submission, Lorin. What about meetings? Are you going to ask for a wells meeting? Who are you going to ask for it with? What kinds of things are you thinking about strategically in that part of the process?
Again, I think you need to start thinking about it earlier than the wells process, because so much of, as you all know, so much of SEC enforcement practice these days is pre-wells because of all the incentives there are, both as a result of statute, when clocks start to run and all that, in discussions taking place before there's an actual wells notice. Look, I enjoy meeting with the front office in either a pre-wells or a wells context and arguing our points in front of them. It's a very important part of the process, and I was glad to hear somebody say, maybe it was Antonio or somebody say earlier today out of the bat that, I'm sure that I expect that the practice of the incoming commission, whoever the enforcement director is, will be to generally grant wells meetings with the front office unless there's a really good reason not to have them. All that being said, your most important constituency in an investigation is going to be the staff attorney. It's going to be the staff attorney, or maybe the staff attorney together with whoever is supervising the staff attorney. Most enforcement leaders, reflexively, as they should be, want to be supportive of the staff, are going to support the staff in close calls. So yes, you want to be looking toward, if necessary, meetings with the director or deputy director of enforcement or associate directors or leaders of the enforcement groups in the regions. And those are important meetings. They're important to have good, strong written submissions for, to have nice, tight presentations, not, 50-page PowerPoints. It's a loser. If you got a 50-page PowerPoint, don't go to the meeting. You're not going to succeed in the meeting. But again, to repeat myself, don't lose sight of the fact that your most important constituency is the staff attorney, and maybe the staff attorney's supervisor, direct supervisor.
Sheldon, you mentioned having the client sometimes attend reverse proffers, Zach or Junaid. Do you ever think about bringing the client to a Wells meeting?
So clients ask all the time, right? My general preference is that clients not come to anything, but I lose that fight a lot. I've had a lot of clients over the years flirt with the notion of having their Wells submission be a video. I had a client, no matter I had with Lee this year, do it for the first time, submitted a filmed video of himself talking. It was hard after that to talk him out of coming to the Wells because, he's already put himself on video and he really wanted to be there. So look, at the end of the day, it's client's call, obviously, right? It's their case and we represent them and they get to make the decision. You got to advise them of the risks of coming to any meeting, right? Wells or not, I've had clients ask if they could come to weekly calls with the staff. Thankfully, I've convinced them never to do that, but I've had them ask, could they come to a discussion on a particular issue about which they're knowledgeable? And I've tried to gently tell them that's like a lose-lose for them across the board, but sometimes you lose that fight and they insist on coming and it typically goes poorly, but occasionally it goes well and you get the I told you so. I think when you are trying to put a individual human face on a larger entity, having them at a Wells meeting can be effective, because sometimes we think of very large entities as being, autonomous and nameless and faceless, and they're not. But in general, I try and talk clients out of coming to any meeting with the government.
And why is that? What have you seen go south?
Well, so the two things that go poorly are, the question, you get a factual question asked of you, and you know what the question's going to be, and you know what the answer is, and you know it's not a great answer. So the choices are they're going to say, I don't know, which doesn't look good at all if they're in a position where they should know the answer, or they're going to give the answer, which is probably not going to look great, or they're going to come across as evasive and muddled, which is also not great from a credibility perspective. If there is a particular historical issue about which they are the only person who knows, maybe. But in general, I think it is more pitfall than whatever the opposite is, a swinging rope, whatever the Tarzan version.
A ball you could hit.
Yeah, right.
I'd add that it depends. If it's an individual, I almost never, I could say never, bring the individual in for a Wells meeting or any meeting with the staff. If it's an entity, I think the general rule, I agree 100% with Zach, is probably not, but there are circumstances, especially if it's highly contested, and you bring in the general counsel, for example, or you to show that, look, we're serious when we say that this will get litigated, that this is just not us saber rattling as lawyers. I think that's effective. Sometimes it's helpful to bring in the new CFO from a tone perspective, that you have, this is the new face of this organization, we've had accounting issues, this is the person who's competent, qualified, is engaged in significant remediation. I found that to be helpful.
Yeah. Do you think any of your strategy decisions are going to change with the new administration?
Well, I don't think so. I think with regard to the new administration, there's been some publications on the potential new administration and kind of their focus on the importance of the Wells process, for example. So hopefully there'll be more of some of the historical ways that the wells has been utilized. So we'll continue to ask and push for whatever meetings that we can get and whatever opportunity that we have to advocate. Now, you go into these meetings, I don't think the strategy changes. I mean, I've never walked into a meeting where the staff attorney has said, tell us why we're wrong and we're going to close this. You know, it's always, we think we got the better argument, you know, you're wasting your time. And we go in and you got to be credible, you got to focus on the evidence. And I think, you know, to the point that was made earlier, the staff attorney and the supervisor, the immediate supervisor are really the focus to demonstrate that, look, these are the flaws in the investigation from a factual standpoint or a legal standpoint, and make your argument in an unemotional way, but kind of staying true to being credible. I don't think that strategy is going to change from administration to administration.
Yeah, Sheldon, can you talk a little bit about some things you've seen counsel do or strategies that they've employed in what the Wells process that you've found effective? Or vice versa?
Yeah, I mean, in terms of the Wells process, I would say, I would sort of echo what Lorin said, which is not the sort of blunderbuss approach. We take every issue and try to cram it into the PowerPoint. It's like, we're here, we've got about an hour, usually most Wells meetings are an hour. Let's just kind of focus on the kind of key points of disagreement. I think that's very helpful. I think it's rarely productive when defense counsel use a Wells meeting to threaten us to go to trial. I mean, if a case has gotten to the Wells stage, we're serious about the case and we've come to the preliminary conclusion that we can prevail if it's going to be litigated. So simply telling us that your client's going to litigate, I don't think achieves anything. But I will say that doesn't mean that, you know, folks should shy away from providing your views on the risks we will face in litigation, and that's, I think, the difference. And I think savvy counsel, defense counsel, will come in sort of and summarize how they might try the case, preview the anticipated trial themes, summarize how you're going to maybe use the evidence or the witnesses, and I think that can be very effective. That approach can be very helpful. The sort of the threats or things like that, I think the tactics are kind of less effective.
What about in settlement negotiations? Are there things that have been effective for counsel doing and like changing the language in the settlement in an OIP or you know, getting a particular part of the relief downgraded or removed, anything like that?
Yeah, I mean, I think for the OIPs, again, this is just my observation, it's helpful for the defense lawyer to lead with their most important points for their clients, like what are the must-haves, and we're just kind of focusing on that. It's not great to get back a document that's completely been redlined with no explanation, you know, and sort of like, you know, and similarly, it's not productive when we kind of get back a lot of non-starters. Like, these are templates, you can go online and look, they've been done this way for the last 25, 30 years. I'm not going to be able to negotiate and change sort of stock language that are in the agreements. And so if we can focus our dialogue and be around the must-haves and, you know, and then if we can't agree, we can at least talk to you about this is why we're having trouble or this is why we can't agree. I think that can help us narrow the focus.
All right, we have 1 minute left to talk about litigating with the commission. Lorin, you want to give your sort of high-level takeaways on litigating, which is pretty rare, so it makes sense that we are only spending a minute on it.
Yeah, you know, it's funny, earlier I made the distinction between SEC testimony and the civil deposition. I think once you're in litigation, you're in litigation. It does have similarities with, you know, standard civil litigation. I think that, you know, in appearances before the court, you know, where I can, I try to cast myself as the more reasonable party, the more reasonable person in the room, pointing out places where I can that the staff may have overreached in a complaint, or where there may not be evidence to support allegations in a complaint. But you know, once you're in litigation, you're in litigation, and it's, you know, it's not as rare as you say, Lara. I'm handling litigated cases right now where the SEC is on the other side, and it's different dealing with the staff in a litigation context than an investigation context.
All right, well,
The gloves are off.
Thank you very much. Great panel.